Good morning, everyone. I believe that we are now live. It's prompt at 9 a.m. I'm going to give a short introduction and then we'll get started. We have more people joining, so we'll use a little bit of time now to introduce ourselves before we get going. I just want to thank everyone for joining today. I know that we initially had this scheduled as a hybrid event, and with the increase in cases and all of the challenges that has brought for us and for many people professionally and personally, we thought it would be prudent to reduce additional risks and to invite people to attend this session remotely. So as much as we're eager to meet all of you in person, and to resume normal business activities and networking activities, and to enjoy free breakfast, we thought it would be better to and safer to go remote today. My name is Jonathan Noble. I'm a partner here at Arbitrary, and I'm joined today by my associate Taskeen Mullah. You can see our bios on the screen. We work in a number of areas, but one of the most important practice areas for us is labor and employment, and we're pleased to present this seminar to you today. If we can go to the next slide, we'll just introduce our practice a little bit. So for those of you who aren't that familiar with Arbitrary, we're one of the largest law firms in the Middle East. We have 9 offices throughout the region and in Germany, more than 60 lawyers. And we're fluent in a number of languages and assist multinational firms and clients from all over the world, including Japan, East Asia, Central Europe, and broader Europe, and North America as well. We've also been recognized by a number of journals and have been ranked in Chambers and Legal 500. Our labor and employment practice, we can move to the next slide. We focus on all aspects of labor and employment law. That's everything from drafting contracts and giving general guidance to drafting employment handbooks, which we think will be an increasingly important part of a comprehensive HR approach with the new law, as well as high stakes terminations and retention issues, as well as employment issues related to non-compete and confidentiality. And that's an area where we excel and have advised a number of our multinational clients on contentious terminations in the executive level. So without further ado, I know we have well, let me first, if I can just take a step back, I'd like to establish some of the rules for today. We like to have interactive sessions, and that's why we wanted to be live, so that people could raise questions, we could have debate, we could learn about what's going on in your companies, and hopefully learn from one another. Unfortunately, the forum that we're on now, this Zoom webinar, is not conducive for that. So we're going to present on the relevant changes to the law, so on the new law. Taskeen and I will present, and then we're hoping to have a healthy amount of time, at least a half an hour, if not longer, to answer questions. And we'd ask that you put those in the Q&A box so that we can sort through them and organize them to avoid repetition, and hopefully spend a good amount of time at the end of the session answering questions. Again, we think that people being able to share what's going on in their businesses, their concerns, their approaches, is something that really is a strength of an in-person meeting, and we're sorry that we're not able to do that today. This is a space from a statutory perspective and a regulatory perspective that's going to continue to be important and relevant for all of 2022. And so we're hoping to have more seminars on these topics, particularly when implementing regulations come out, once we've had a month or so to see how things go. And we're hoping that as the COVID situation improves, that we'll be able to meet in person and have a forum for people to talk about issues. Another point is that we today will not be able to answer company-specific questions or give legal advice related to your particular issues. So if there's a company-specific query, please save that for an email And depending on the inquiry, we would be happy to advise after, if you're an existing client, on the basis of our ongoing employment, of our ongoing attorney-client relationship, or enter into a new attorney-client relationship with new clients. But we're going to talk generally today, and we're not going to be able to answer particular queries. So please keep that in mind when you're crafting questions. And again, we're happy to answer anonymized questions in a very general way to help everyone, but cannot help answer direct questions. So let's move on and let's get started today. I don't want to. I want this presentation, and it'll probably be a little bit dry, and I know that the conversation is what's where there's real value. So we're going to try to get through this in a reasonable time and not have it be too boring. So what's happened? Let's just take a step back. Since 1980, with Federal Law Number 8 of 1980, we have had a single UAE federal law and ministerial resolutions, etc., that have governed employment relations between employers and employees in the UAE, and particularly expat or private, largely expat and private sector employees in the UAE. At the last quarter of last year, we had a brand new law that was introduced. That's Federal Law Number 33 of 2021. Comes into force 2nd of February. There's still a ton of uncertainty. We've been given just a few months, basically, to figure out how this is going to work, and we still haven't gotten guidance from the Ministry of Human Resources and Organization on a lot of things, but this is a sea change. It's happened very quickly. There's a lot of continuity, frankly, between the old law and the new law, but there are a number of new concepts that have been introduced that are relevant and are going to change the way that companies contract and engage with employees from the executive level all the way down. Let's move on to the next slide. So what we know is the black letter, the very basic elements of the law that were published and are available. What we don't know, there are numerous references to implementing regulations, and those have not been provided yet. According to the law, the cabinet, and based on ministerial guidance, is going to issue implementing regulations. I saw a news report, I think late on Friday of last week, stating that those regulations would be issued shortly, imminently, that they were available. I've hence looked on the internet all weekend and tried to find references to this also in our the professional news sources that we subscribe to, and have not found anything yet. But I think that very early this week, we're going to see implementing regulations, and that's going to set out things like new templates for employment contracts, defining terms that are left undefined, like working hours, and giving a lot more guidance and fleshing out the law. So this is TBD. It's coming, we've been told. And again, it's key for us to be able to successfully implement the new law at companies by February 2nd. So this is coming. Next slide, please. So what does this new law do? It effectively repeals Federal Law Number 8 of 1980 and any amendments or provisions contrary to the new law. Previous decisions, regulations, and rules where they haven't been as explicitly addressed in the new labor law remain. So those fill in the gaps, and that leaves a lot of, there's a lot of now room for us to read things in. But again, the main provisions are covered and are effectively addressed in the new law. So what are the objectives of this new law according to the law itself? They want to ensure efficiency in the labor market, attract and retain the best future talent and skills, provide an attractive business environment for employers, regulate labor relations and determine rights and obligations of the parties in a balanced way. And this is an interesting provision because previously, depending on who you talk to, there was either thought to be a clear employee bias in the law and in court implementation of the law, or things that were very pro-employer. But the attempt here is to balance the employment relationship. Also, it's supposed to enhance flexibility and sustainability of the labor market, and support and enhance skills of private sector employees. And this is, I think, all of the laws that are coming into place that were published in the last month or so 2 months. This is all about innovation. This is all about the government trying to present a regulatory framework, a statutory framework that matches the marketing vision of the UAE as a forward-thinking country that can attract top-level talent to engage in cutting-edge business. So who does the labor law apply to? Look, it's basically the same as the old law. It's the private sector. It's any establishment, any employer and employees in the private sector within the UAE, as it was previously. Employees of federal and local governmental entities doesn't apply. Members of the armed forces, police and security services, and domestic workers as well. Now, agricultural workers, and again, this isn't probably relevant to most of the folks on today, were excluded previously. They're now included. So if you're running some kind of hydroponic farm or something in the agro space, the law now applies to your farm workers. Something else I should mention is that, and I think we're going to have more clarity on this. In the past, there was a lot of questions about whether semi-governmental entities or private entities with governmental ownership, whether the law applied or how it was applied. It's pretty explicitly clear now that if there's not a ministerial decree creating that entity and carving out an exception, that those entities are now included in the private sector and as part of the labor law. So you could have an entity that's 100% owned by the government, as long as there's no implementing law that carves them out. Those employees would now be subject to the labor law. Next slide, please. So let's get into the employment relationship. Something really important here, and this has always existed, but this was codified and made very clear in the new law. You cannot work in the UAE, and no employer can hire an employee unless you have a work permit from the ministry or from one of the free zones, etc. This was always the case, but this makes it very clear. The penalty, the fine, is 50,000 to 200,000 dirhams. So that has considerable bite. And again, this was always the case, but as we know, work relationships are often informal or aren't formalized quickly in the UAE, and now this puts teeth, although we'll see how active the ministry is in implementing or in applying the new law, but makes it clear that you cannot employ somebody without a visa under your sponsorship. And this is, again, always the case. You cannot charge an employee for costs of recruitment and employment. This is a basic principle of international labor law and employee rights, but is enshrined in the new laws. Next slide. So the old law, and I think this is part of the efficiency and flexibility and modernization drive, the old law was silent on modes of work. It presumed full-time, 40 to 48 hours a week, 6-day-a-week work week. There were regulations that went into place pre-COVID, and then especially when COVID hit, that really worked to change this and to allow for temp work. That has now been codified in the law. So the full-time model still exists. It's still the dominant paradigm for how we think of labor relations. But now, and supposedly we'll see templates coming out from the ministry, there is an understanding and an acceptance of part-time, temp work, flex work, and other models as the implementing regulations may call for. So this is going to bring out a lot of new questions. People who have full-time jobs who might want to do moonlighting work in areas, let's say that you're a computer programmer, but you want to work at Coca-Cola Arena in the event space at night on your own time. These kinds of things are which we used to in freer labor markets was part of the way people worked. In the past, this was very difficult to do legally here, and we're going to see a lot of these issues come up now, hopefully with these new models. Next slide. So in addition, we're all familiar with, or I hope many of us are, with the unlimited and limited term contract system. That's done. There are no more limited and unlimited terms. For full-time employees, there's a limited term contract that should not exceed 3 years. So you can have a 1 year, 2 year, 3 year limited term contract. Those are basically subject for renewal under terms that we're going to get to. I know we're going to have lots of questions on this, but employment contracts that were valid prior to the new law, they cannot be revised to comply with provisions of the new law unless the amendment is beneficial to the employee. employment contracts that conflict with the new law are void unless they're for the benefit of the employee. The implementing regulations are going to provide greater detail on these types of employment contracts. In addition, and I know we'll talk about this at a later slide, people have a year basically to conform unlimited term contracts to the new limited term model. And so we're going to have to see how that shakes out with the implementing regulations. Next slide. So, yep, I jumped ahead a little bit. Employers have to convert unlimited term agreements into limited term contracts within a year from the new labor law coming into effect, so February 2023. You cannot amend a limited term contract prior to promulgation of the new law unless the amendments comply with the updated law and are to the worker's benefit. So there is space right now to start doing these conversions of status. I think, again, this is a general comment. We really don't know what the templates are going to look like and how this is going to work out. So I would say we need to be prepared and prepared to move rapidly, but we don't yet have the information needed to accurately implement these changes within a company. So these limited term agreements or this new full-time format, they can be extended for one or more times for similar or shorter periods at the consent of both parties. As was before, cannot charge for costs of recruitment, employment, or renewal. And there are certain instances where you can charge for that. We'll get to that in a second. So again, probation. Things have changed here, but the basic principle, which is that an employer can place an employee on probation for a single time, not exceeding 6 months, remains in place. Now, termination during that period has changed. Let's move to that. Both parties are now responsible for paying compensation in lieu of notice equal to the employee's wage if the relevant notice provisions aren't followed. That's the first point. Second point, the employer now has to give 14 days notice during the probationary period to terminate. An employee has to give 30 days written notice. And the employee is responsible for repaying recruitment costs unless otherwise agreed during that period. Expatriate employees, so these are people that are brought in to work, again, have to serve a 14-day notice period. And if they want to return to the UAE to work within 3 months of termination or resignation, they have to again compensate the employer for recruitment costs unless there's agreement otherwise. If the expat employee doesn't follow the notice requirement and leaves the UAE, pardon me, they can be banned from re-entry for a year. And the ministry can exempt job categories from these provisions. We anticipate, or I would think, as is in the past, that white-collar employees, employees with degrees, knowledge workers will likely have some exemptions from these. But again, this is an attempt to try to balance the relationship. We want people to be able to move freely and to find the best work relationship for them. On the other hand, there's a sense that people have come in and have been free riders on a good faith employee paying costs of recruitment, et cetera. And if a new employee wants to move somewhere, there's the idea that they should reimburse the employer for these startup costs. Let's move to wages. In the past, you were supposed to only pay wages in dirham. Now you can pay in other currencies. So I was talking to Taskeen about this. For white collar workers, there's an obvious benefit to this, and people have frankly likely been paid in British pounds, US dollars, euros, yen, etc. For years, or some portion of their salary back in home country. This now opens the door, for example, for blue collar workers to be able to be paid in pesos or rupees, some portion of their salary, and could theoretically, if you had an employment agreement in place, reduce remittance costs, et cetera, and allow for workers to have a salary deposited directly without having to use a currency house or some other kind of company. The law mentions, again, the possibility of a minimum wage to be determined by the Cabinet of Ministers. We'll see if that's actually implemented. There's been talk of this for years, but the law envisions such a minimum provision coming into place. This is going to be really relevant for calculating end of service, et cetera. Definitions. The basic wage refers to the wage specified in the employment contract for work on a monthly, weekly, daily, or piecemeal basis, exclusive of allowances, pretty similar to what it was before. And again, I want us to focus on what is it? It's the wage paid for monthly, weekly, daily, or piecework. So if you have a monthly employee, you're paying them 10,000 dirham a month. That's the basic salary. That's going to be the basic wage, and we're going to then divide, etc., based on that. The wage is the basic wage plus cash allowances, and in-kind benefits. And there's now an explicit reference to commission bonuses in the definition. It was there before, but it's now more clearly stated. Deductions. In the past, there was a lot of uncertainty about what you could or couldn't deduct from an employee's salary. That's been made more explicitly clear. You can recover loan amounts, free of interest and not exceeding 20% of the wage, retirement and social security benefits, social schemes or benefits that are offered by the employer for violations of sanctions. The company's list of sanctions. Debts due to a court judgment, so garnishment of wages. Again, how that will work is to be seen, and damages that the employee may cause on the work site. So changes to work duties, and again, I think this is an area that could be a potential, a real potential source of conflict between employees and employers, could lead to litigation. In the past, basically, contracts stated, and the law was silent on this, that you could give an employee new duties basically at will. If there was a scope of work, generally it was fairly broad, and you could, in the past, force somebody to take on new duties even though it wasn't clearly defined. Now, without an agreement in writing, an employee may not be assigned to substantially different work than what was initially agreed. There is an exception if the assignment's temporary and to avoid an accident. But again, you have to have mutual consent of the parties. And we'll get to this, this is cause for termination without notice by the employee if they are forced to engage in assignments that they weren't contracted to engage in. So again, potentially a major source of conflict and a very important issue for HR heads and their teams to work through is clearly defining a scope of work, making sure it's flexible enough to countenance work that may not currently be within the scope but could be done, and give employers flexibility within a scope to consider what could happen within a 3-year term. So again, a new change and something that has the potential for a lot of conflict and will require careful drafting and consultation. Non-competes. So this, again, the law codifies basically practice and what had been in the law previously, but makes it a little bit more explicit. Non-compete provisions now only apply when the work assigned to the employee includes access to clients or trade secrets. So again, if you have a blue-collar worker or somebody at Zoom who's making 1,500 dirhams a month, this is not a person that should likely be bound by a non-compete. We're talking about senior level staff, sales staff, people who have a potential to materially impact the performance of the business by competing. They can be enforced when the employee seeks to compete with the employer or wants to join a competing project in the same sector. I'll just say, then we can move to the next slide. The confidentiality and non-compete provisions in other laws, so the cybercrimes law, the civil code, penal code, those things are still going to apply, although again, those laws are also in flux and have changed. But we need to understand that this is codified in the non-compete provision in the labor law, but there are a number of other laws that could be applicable depending on the situation. So what is it? What's the relevant non-compete provisions? Cannot exceed 2 years, as previous, and that is new. As previously it was the case, it has to specify duration, place, and type of work. And as we always recommend, the more specificity you can have here, the better. Place, if you can limit it to a particular emirate, type of work, if you can limit it to a particular sector, and maybe even as, for example, DDA contracts have, list relevant competitors, you're more likely to have success, although again, it's very difficult to enforce these. The provisions are void if an employee terminates the employment contract in violation of the law. I believe that's a mistake and should say the employer, excuse me. So if the employer cannot violate the contract and then bind the employee, and we believe that there's going to be more specificity on damages and potentially injunctive relief, which let's see in the implementing regulations. So discipline and termination. The disciplinary provisions or have changed. There was a whole section in the old law. The new law is much shorter, and I think that the implementing regulations are likely going to contain due process procedural requirements on how these are implemented in the workplace. But this is an explicit acknowledgement that the way things used to be, where you could go about terminating an employee without following due process, that's likely changing in the UAE. So the law basically now just says, hey, you can impose the following sanctions: reprimand, warning letter, pay, suspension, deprivation of wage increase, and promotions and dismissal. You need to do it. You cannot do it for acts outside of the workplace unless they're related to work. And if we can move to the next slide, you need to do this through an investigation, and you need to then let the employee know the results. During the investigation, you can suspend the employee for 30 days. During that time, you can dock their pay by 50%. If the investigation results in no discipline or a simple warning, the employee is entitled to the back pay back. If it's a greater disciplinary step, then they forfeit potentially the wage. Wage can be suspended fully, so you can have a person who's suspended from work, suspended from salary, if an employee is suspended for reasons of an offense against a person, property, honor, or honesty. So, for example, if there's a claim of theft or embezzlement in a company, you can suspend somebody, yeah, there you go. Next slide. Termination of employment. So, notice period. Let's just get that out of the way. Used to be that this was unclear. It was codified in the ministerial regulation, I believe, in 2015, 2016, and that has been carried through the new law. So you have to give after probation, you have to give a minimum notice of 30 days and a maximum now of 90 days. It used to be that we would see senior executives, for example, have a 6-month non-compete, and that was for the benefit of both the executive and the employer. That is gone. Now, can companies have a side agreement with senior executives to stay for a longer period? Possibly yes, but likely that would be a provision that's null and void and would not be enforceable. This is a new provision. If the employer terminates the employee has a day a week unpaid to search for new work and to go out and interview. So it's a provision that balances this out and gives some benefits to the employee. Compensation in lieu of notice. So if you don't follow the notice period, you need to pay compensation in lieu of notice. Again, that used to be largely unilateral. That is, if the employer didn't follow it, they were responsible for paying compensation in lieu of notice. If the employee didn't follow the notice requirement, it was half of the wage. Now it's both parties, and the compensation owed is the worker's wage for the notice period that wasn't served. So reasons for termination, and I highlighted C and G here. You can now terminate, there used to be provisions, kind of Byzantine provisions in the old law about how you could or couldn't terminate. That now has changed. So you can do it in an agreement between the parties, expiration of the contract. So after 3 years, you can say we're not going to continue employment. Unilaterally upon the desire of either party, as long as the agreed notice period is shared. Death or disability, imprisonment, permanent closure of the work establishment, and if the employer becomes bankrupt, insolvent, or unable to continue business for economical or extraordinary reasons. Now, I've seen people say that is a recognition of redundancy. That if if there are economic reasons to let somebody go, that this now is a clear indication in the law that you can let somebody go for redundancy. I don't read that in this provision. It certainly makes an argument for employers, but I think it's far more arguable that you'd be able to do that under C than under G. But again, the reason that we used to have this discussion about redundancy was in relation to arbitrary dismissal, and as we'll see, that's a concept that has been largely removed from the new law. So termination without notice. I'm not going to get into this in any great detail, but this is largely a recitation of the old Article 120. There are some new things, but basically this is termination for cause. And again, we'll have to, as many of you know, it was very difficult in the past to terminate somebody under Article 120 for cause. Courts were reluctant to accept a termination for cause unless there was clear evidence that supported that determination. We'll see how this is implemented. Again, because you can now terminate for a valid business reason, basically, and likely avoid a claim of arbitrary dismissal, or at least have a lower risk, this may be less relevant, but it still exists, and again, it's kind of a recitation of the old Article 120. Next slide. So, a little bit new. You have to have an investigation, and if the employee causes gross material loss, you can now dismiss them without having to inform the ministry. It used to be that you need to do that within a very short period of time. But again, sort of an increased reference to due process in this, if you're going to terminate without notice for cause. Now, there was at Article 121, this was is it 121? Yeah, this is an old Article 121, which permitted employees to terminate without notice of the cause. That's been revised, and there's now more reason that employees can leave. So the employer breaches obligations under the employment contract, and the employee would have to serve the ministry with 14 days notice. I think the most common place where that would be applied would be non-payment of salaries. Assault, violence, and harassment. Again, the ministry needs to be involved ostensibly if that's the case. A failure to remedy risks to safety. And the final one is if the employee is made to perform work different from the contract without consent. And so that is a new development and significant. Unlawful termination. So it used to be called arbitrary dismissal. It's now unlawful termination in the translations that we've seen. It's arbitrary dismissal. That is, if you terminate somebody without a valid business reason or good reason, is removed. Now, if you dismiss an employee due to lodging a complaint with the ministry, or due to a valid lawsuit filed by the employee, you can get compensation. As determined by the court based on the type of work, term of service, and damage sustained by the worker, shouldn't be more than 3 months of the wage. Let's go back to B really quickly. There was always a provision in the arbitrary dismissal clauses in Federal Law number 8 of 1980. So it used to be 122 and 123 of the law that allowed you to file an arbitrary dismissal claim if you made a complaint and were terminated for it, basically a retaliation complaint. This again is read in there, and there's this what I think is an ambiguous statement about or due to a valid lawsuit filed by the employee. So does that read back in arbitrary dismissal? That is, I'm raising a labor complaint, a lawsuit, because I was terminated without a valid reason. My work performance was good, and I'm entitled to 3 months compensation. We have to see how this is going to work out and how courts are going to consider this. But I think that it's likely too soon for us to say absolutely that the old claim of arbitrary dismissal for a valid business reason is gone. And enterprising labor and employment lawyers on the plaintiff side, on the claimant side, will likely still make an unlawful termination claim as part of the damages owed or claimed. And we will have to see again how courts interpret this new law. But It's unclear from my perspective whether this is completely abolished or whether this is basically just a different way to say if you file a lawsuit alleging that you were terminated for a particular reason, that potentially you would be entitled to damages. That wasn't a valid reason. Let's move on. Which leads me to labor disputes. So there are now provisions related to group disputes. We'll get to that, but when we talk about the individual disputes, basically it's the same procedural steps that used to be. There's some change. You need to go to the ministry or the relevant free zone for amicable settlement. If that's not possible, the ministry will then refer to the competent court. During pending settlement, you cannot impose sanctions on the employee that would harm the employer or other employees. This is a key provision. The employer may be ordered to continue payment of wages for at least 2 months pending resolution. In the past, the general practice, I would say, for employers threatened with a labor lawsuit, an employment lawsuit, was to withhold payment of any further salary, end of service benefits, annual leave, etc., whether the amounts owed were disputed or not, pending the resolution of the suit in court. Now the law makes an explicit provision that should not be the case. The employee should continue to receive salary for at least 2 months after the lawsuit is initiated. This gives more powder, right? It gives a little bit of economic balance and allows the employee potentially to fight on if they were dearly in need of that compensation and had it cut off. Now they should be receiving that compensation. As was previously the case, the ministry going there is a mandatory step. The same 1-year time bar applies as was previously the case, and also as was previously the case, labor actions where the amount in dispute is less than 100,000 dirhams are exempt from court fees. That's to encourage low-level workers to present claims. So group settlement, I think things are likely the way that they were before. This is not a pro-organized labor jurisdiction. But if there are group disputes, the idea is that the employer and employee should try to resolve that, and then the ministry will get involved if they're not able to. And the ministry is empowered, and we've seen this in a number of joint labor actions in the past. The ministry and other governmental authorities in the relevant emirates are empowered to take actions necessary against the employer or the employees, for that matter, as long as they're in the public interest. Okay, end of service. So the law makes it clear that this is specific to expatriate employees. UAE nationals receive pension and social security. It's based on working days, no longer calendar days. Still based on basic wage, excluding allowances. It still may not exceed a wage of 2 years. I know there's been a lot of questions about this working days versus calendar days. Look, from my perspective, the vast majority of employees are on a monthly salary. That implies that they're paid on the basis of their work, that is the working days. And so I think the calculation would be on the basis of that amount, not divided over 30 days. We'll get there probably in questions, but next slide. How does end of service work? 1 year of continuous service, 21 days for the first 5 years, 30 days after that. No differentiation between limited and unlimited contracts. For current unlimited term contracts, employers can continue to calculate end of service in accordance with the old labor law through the next year. Once the grace period ends, we'll need to do the new calculation. There's no end of service gratuity reduction upon termination without notice or employer resignation. Those are new. The law indicates the possibility of an alternative plan for end of service that could pave the way for some kind of national pension or emirate level pension plan where employers are forced or are asked to accrue end of service benefits on behalf of their workers and pay them into a national fund. Again, this is another major development in the world of disputes. Wages and other dues must be paid within 14 days of expiration of the employment contract, regardless of whether there is a dispute. So ostensibly, you could have a very large dispute that would arise and have to be settled in court. The obligation in the law is that the employer now needs to pay the statutorily required benefits, regardless of the existence of that dispute. And again, that sort of likely balances the relationship between the parties a little bit more when a dispute arises. That I think closes my portion off, and I'm going to pass it over to my colleague Taskeen Mullah to proceed with the rest of our presentation. Thank you very much, and I look forward to questions shortly.
Thank you so much, John. Hi, everyone. It's such a pleasure to be with you today. So let's jump straight back in with employment obligations. If we can go to the next slide, please. So employer obligations. The law previously did not address these so specifically as it does now. And the new law now includes a good few employee-centric provisions which aim at active development of employees. These obligations include now not withholding employees' official documents, which, as we know, has been a prevalent issue in the past. Also, employers are obliged to maintain registers of workers in accordance with MOHRE guidance. Employers must create policies around promotions, bonuses, and sanctions. Employers must also provide for skills development and training. And this aligns really well with the ministry's competencies under the new law, which state that they want to invest in employee training and empowerment. Employers must also provide a safe workplace from injury and disease. And this, of course, is really relevant for us at the moment in our current COVID times. Employers must also ensure an employee's awareness of their rights and obligations. Once again, these lead towards active empowerment of employees. As per the previous status quo, employers are required to also provide for health insurance and accommodation. Next, we can move on to the corresponding obligations for employees, please. Employee obligations include good conduct and behavior, personal performance of their work duties, which must also be in accordance with their employer's directions. Employees must maintain confidentiality and trade secrets. This responsibility is often also reiterated in employment contracts, supplementary contracts, depending on the role and industry of the employee. Employees must also observe all health and safety instructions in the workplace. Next, we'll focus a little bit on updated employee rights, including forced labor. So forced labor is an important new provision and also aligns a bit with the topic of work assignment, which Jonathan spoke about a little bit earlier in the presentation. Employers are prohibited from forcing employees to work against their will or to threaten employees with sanctions to force them to perform certain work or services. A really significant development as well under the new labor law is this very specific prohibition against sexual harassment, physical, verbal, or psychological abuse against employees. It, of course, remains to be seen how companies will deal with these provisions, and it's always recommended to have necessary policies in place to prevent these acts and to provide for disciplinary provisions and escalations in the event of breach. This nicely complements as well the new provisions on equality and non-discrimination, which, of course, has been a talking point since the issuance of the new law. The labor law was previously largely silent on any equality and non-discrimination, and the new law provisions will have far-reaching implications and is, of course, a step to align the UAE labor law with certain global standards, especially in the times that we live in now, where we are all hyper-aware of these topics. Discrimination under the new law is prohibited on the grounds of race, color, gender, religion, nationality, and disability, where this discrimination reduces equal opportunities or prejudices equal access to employment or enjoyment of rights. It's interesting to note that the new law remains silent on discrimination on the basis of sexual orientation and political ideology at this stage. Next slide, please. It's important to note that action to enhance the participation of UAE nationals in the active workforce will not be considered discrimination under the new law. And as we've seen under certain things like Projects of the 50, these encourage participation of UAE nationals in the workforce, explicitly so. Under the new law, women must receive equal payment for the same work as their male counterparts. It's also specifically mentioned that all rights under the new law apply to working women. It now remains uncertain how these provisions on equality and non-discrimination will be enforced, but we see that the general sanctions for breach of the new law are fines between 5,000 dirhams and 1 million dirhams. Next slide, please. Fines may also be subject to a multiplier, which depends on the number of employees affected, and repetition of these offenses may lead to imprisonment or a double in fine or both of these. It'll also be interesting to see how these claims might be managed by the ministry and the judicial system, and whether victims will be able to sue their perpetrators. This is definitely a topic that I think will be expounded upon a lot in commentary, as well as in the implementing regulations. Next, we'll talk a little bit about work hours and overtime. So work hours and overtime under the new law remain largely the same. You can see a maximum of 8 hours a day and 48 hours a week. Employees may not be required to work more than consecutive 5 hours without being allowed at least an hour's break. This break, though, will be excluded from the work hours. Overtime entitlements are specified in the new law. However, unlike the old law, there are not yet any specific exclusions from overtime payments. For example, in the old law, it specifically mentions already that supervisors and managers are excluded, but we understand that it's specifically mentioned in the new law that any exclusions to overtime payment will be covered in the implementing regulations. Next slide, please. Overtime may not exceed 2 hours a day, and payment for overtime will be the basic wage, i.e. payments excluding all allowances, plus 25% on this amount. When working on a day off, an employee will be entitled to the basic wage plus 50% on this amount, or a day off in lieu as agreed with the employer. Any overtime worked between 10 p.m. and 4 a.m. will then entitle an employee to the basic wage payment plus 50% for the day. Next slide, please. Next, we'll cover leave and rest days. And there are various leave entitlements specified under the new law. We'll start first with annual leave, which we are all familiar with. So employees working in excess of 1 year are entitled to maximum 30 days of fully paid annual leave. When an employee has worked more than 6 months, but less than 1 year, the leave allocation will be 2 days per month for this employee. Annual leave days may now include public holidays when these public holidays fall amongst the annual leave days taken. This, however, is not mandatory and won't be the case where the employment contracts don't provide for this, or where employers provide for more favorable leave conditions for employees. When an employee leaves the company before availing their annual leave balance, they will also be entitled to a prorated leave for part of the year that they've served. Annual leave may only be carried over to the following year upon consent from the employer. Part-time workers under the new law will be entitled to their annual leave, which is commensurate with the actual number of hours that they have worked. The new law specifically states that employers may not prevent any employee from taking their leave that's accrued for more than 2 years, unless, of course, the worker wishes to carry the leave forward or receive cash payment in lieu. Next slide, please. We see now that there's certain compensation schemes provided for regarding leave. So compensation for unused annual leave is based on the basic wage, and an employee is entitled to payment for unused leave when leaving their place of employment. Employees on probation are not necessarily entitled to leave. However, when an employee approves leave during the probation period and the probation period happens to be unsuccessful, that employee's compensation benefits then will kick in, and they will reserve the right to compensation against the remainder of the leave balance that they have not availed. Compensation for leave, though, is a complicated topic and will be further clarified by the implementing regulations as stated in the law. Next, we'll move on to sick leave. Upon completion of probation, an employee is entitled to 90 days of sick leave. As we can see, the first 15 days will be fully paid, the next 30 will be at half pay, and the remainder will be unpaid. Previously, there was a cooling off period after probation before employees were entitled to take sick leave. This is now no more. Once your probation is done, you will be entitled to your 90 days of sick leave. However, it must be noted, though, that during probation, an employee won't be entitled to paid sick leave. An employer may terminate an employee where sick leave is exhausted and the employee is unable to return to work. The employee will, though, still be entitled to all their dues if they are terminated in this case. Next slide, please. Looking at maternity and paternity leave entitlements, there have been some changes. With respect to maternity leave, these have been increased from 45 to 60 days. The first 45 days will be fully paid and the following 15 will be on half pay. In the event of any postpartum complications, there'll be 45 days of additional leave available to the new mother. This entitlement in terms of postpartum complications, though, has been decreased from the previous 100-day entitlement under the old law. In the case of infants with special needs, new mothers will be able to take an additional 30 days paid leave on top of their maternity leave, and this may also be extended for another period of 30 days unpaid. New mothers, once returning to work, may still continue to take 2 breastfeeding breaks a day, which don't exceed an hour. However, this entitlement is now for 6 months only. This is a reduction from the previous 18-month entitlement that was available under the old law. We see under the new law that paternity leave is now specifically mentioned, and 5 days are available to new fathers up until their children are 6 months old. Next slide, please. There are now new categories of leave entitled miscellaneous leave under the new law, and these include bereavement leave, which we see is available from between 3 and 5 days, 5 days for spouses, and 3 days in the case of death of other family members such as grandparents and children. For employees of 2 years or more, they will be entitled to 10 days of study leave. However, they must be enrolled in a UAE accredited institution. Emirati employees specifically are also entitled to a paid sabbatical when undertaking national service or reserve duties. We know that pilgrimage leave is no longer specifically mentioned under the new law. However, this could always be clarified later under the new law, under the implementing regulations, excuse me. Unpaid leave is also a topic that may be further agreed between the parties where it's not specifically mentioned. Next slide, please. For termination on leave, it remains that where either party terminates employment whilst an employee is on leave, the notice period will then kick in and commence on the day after the employee returns from leave. Next slide, please. Looking at rest days under the new law, employees are entitled to at least 1 paid rest day per week. And this is no longer mandated to a Friday only under the new law. And this actually aligns quite well with the new work week, which certain private sector employers have also chosen to adopt. Employers may not work for 2 consecutive rest days unless these are day workers. Next slide, please. In terms of unauthorized absences, expat employees must pay particular attention to this clause, as this essentially relates to employment bans for those absent from work without any legitimate reason. So when an expat employee is then absent without legitimate reason, they will not be granted a work permit to join another employer for at least a year. The original employer must, of course, however, inform the ministry of this extended absence without legitimate reason. The law states that certain work categories may be excluded from this provision by the implementing regulations, and procedures for this are also yet to be defined under the new law. Next slide, please. So looking at penalties, these have been increased and expanded across breaches and may also reach up to an amount of 1 million dirhams in certain cases. Unless, of course, there's a multiplier in place for breaches against a number of employees at the same time. So we see that general breaches across the law may see fines of between 5,000 dirhams up to 1 million dirhams. Employers may also be fined up to 100,000 dirhams for using false information to recruit expatriate employees. Another important one is fines of between 50,000 to 200,000 for employing persons, but then not obtaining a work permit, or recruiting an employee and leaving them without work, or seizing your activities as a business without settling an employee's dues. Misuse of electronic credentials to log into the ministry system may see imprisonment or fines up to 1 million dirhams, which is quite serious. Next slide, please. We see that repetition of breaches may lead to imprisonment or double the fine amount that you've originally received, or both in certain cases. It's interesting to note also that penalties to employers may be multiplied, as previously mentioned, by the number of employees affected, and this will then go up to a maximum of 10 million dirhams. With that, we've reached the end of the content portion. Thank you all so much for your attention. I'll hand you back over to John, and I believe we also have received some really interesting questions to answer next. So over to you, John.
All right, well, we did pretty well on time. Have 5 minutes left for our presentation period, so that's good. We've received about a little over 20 questions, and I'm going to start answering those. I may pass some over to Taskeen, but we'll just go question by question and see how far we get. If you have something that you think is really urgent and we need to get there, please put it into the Q&A box and we'll get there as quick as possible. So a couple of things, and just to clarify some points. The first question, can a fixed term agreement be terminated during the term? If yes, are there payments required to be made to the employee in addition to the notice period? So no, it's now ostensibly just the notice period. Again, there's this question about unfair dismissal, but that appears to be no longer as relevant as it was previously. And the old 3-month mandatory compensation for fixed term contracts is gone. So it's simply notice. What happens if the company or the employee failed to give notice prior to the completion of the term? Will the contract be automatically renewed? And yeah, the provision basically is that the parties, if you keep performing it, then the contract is renewed under the same terms. What happens if the notice is not given in a timely manner, i.e. the fixed term finishes at the end of December and notice is given on the 15th? Again, you would, well, it's a good question. Would the contract automatically roll over? I would argue probably not, but you would have some kind of compensation in lieu of notice requirement because you hadn't met the relevant notice period. But again, that's something that is a little bit ambiguous and unclear right now, at least from our perspective. We have an anonymous comment here. We charge recruitment costs for less than a year as part of a retention program. Don't do that. It's not fair to employees. And yes, we know that there are a lot of employees that jump around and that recruitment costs are very expensive. But generally, this is not best practice. It's considered a kind of unfair practice for employees. You get in touch with us. There are other ways that you can encourage retention so that you have return on investment for recruiting a new employee without charging them recruitment costs. Is it possible to start an employment relationship while applying for the visa? And this again used to be very much the case. Look, I think practice is going to continue that people will start an employment relationship while the visa is in process. Is this a violation of the law? Could this lead to penalties? Potentially, yes. But as we know here in the UAE, it's often difficult if you have an immediate need to wait for everything to be processed for people to begin. So I think that's a gray area that we're going to have to continue to negotiate, as was previously the case. Can we start a new visa? Can we start a new employment relationship before the visa is processed but application is in labor? Again, similar question. I think in practice this is going to happen a lot, but technically it's against the law. We have a question here. Is there as a contact point where we can get in touch with if we have further queries on today's session? So you'll have both Taskeen and my email address. Please email me and we'll do our best to get back to you. Again, we can't provide free legal advice. We can provide, we can be a resource for the community, and provide general thoughts and guidance. But if you need a binding legal opinion or advice that you would need to, if we messed up, you need to access our malpractice insurance, we would need to have full engagement. We don't mess up very often, or I can say at all, but again, just to make it clear, if we're going to have a formal engagement on a particular issue, we would need to have an attorney-client relationship. Let's keep moving here. How's part-time going to work? Do you need to have an NOC from the sponsoring entity? I think this is something that the implementing regulations is going to get into in much greater detail. I would imagine that generally, yes, there's going to need to be some kind of NOC. We had a question from a pre-presentation question from an attendee asking about, well, how do we prevent people from working for a competitor in their off hours? And again, the same principles of non-compete would apply, and you just need to make sure that you bind these employees so that they're not working for competitors in their off hours. I think the intention here, right, is that we want to be able to have people who are talented or who have interests outside of a particular line of work be able to engage in those interests and receive remuneration. So if you have a musician who's a great computer programmer but wants to work in a band at night, to be able to do that legally and with the permission of the employer and the knowledge of the ministry, working at Formula One, these other kinds of large events, there could be a very good reason why you'd have members of the team that would want to work on their off hours. Especially all of us are here to earn as much as we can, and so many people would want to use their off time to earn more. We've got a great question here, which I think captures the spirit of all of this. If the new law is effective 2nd of February, how can we be compliant from day one, especially when the regulations aren't out? Yeah, yes, thank you very much for that. I think the UAE is to be applauded for these rapid changes in new regulation and statute. But of course, the short time frame leaves a lot to be desired, especially for large companies that need to have time to implement complex new laws. So I think, as is often the case in the UAE, the goal is to be substantially compliant, to do your best as soon as possible. But there's an understanding that with 14 days left, 2 weeks left, basically, before the new law comes into effect, and no implementing regulations, that likely it's not going to be possible from day one for us to be 100% in compliance. You need to watch this space, look at news reports, be in touch with your lawyers and other HR colleagues and professionals to try to get up to speed as quickly as possible. But there's an understanding that we're not all there yet. Quick point of clarification, and thank you for correcting me. In terms of probation, if an employee leaves during probation and goes to a new employer, the requirement to pay recruitment costs. This anonymous commenter said it's not the employee that pays, it's the new employer, isn't it? And that's absolutely right. I double checked the law. How that's going to happen in practice, right? Whether an old employer would have to file suit against the new employer, whether it would be through the ministry, through a ministerial grievance, is yet to be seen. But it is ostensibly the new employer that would be liable for paying these costs on behalf of the employee, not the employee. Couple questions here about probation. You mentioned reimbursement requirement if an expat employee terminates and returns to the UAE within 3 months. Does that mean there's no free movement, or is this only applicable in case of termination during probationary period? Again, that's a probationary period requirement. And the idea here is that employers hiring expat workers do spend a considerable amount of money to bring people into the country. And so if you have somebody who doesn't follow the provisions and leaves, that they would need to compensate that employer. Can companies put current employees on full-time work to part-time or flexible work? Again, this is an uncertainty, but I think that the law envisions that people on unlimited term contracts, that there will be within the next year a change to their status. And that potentially as part of that, you would be able to move them to a new status that would likely require their consent, as it would not be as favorable to them, although in some instances it may be something that both parties want. That's something that's going to have to be seen in each instance. Regarding the scope of the new labor law, are there any clarifications regarding application in the free zones? So no, there aren't, but the vast majority of the free zones, with the exception of the DIFC basically, and I believe ADGM have, I guess JAFSA has its own regulations as well, DMCC, but the vast majority of free zones follow the labor law, and even those free zones, for example, JAFSA, they have their own employment regulations, but once you get to a dispute, you mediate out and go to court, and they follow largely the labor law. So I think that we're going to be in a similar hybrid situation where the labor law applies, but there may be some specific carve-outs for certain free zones. We have a question about whether we'll be sharing this presentation with attendees. Please get in touch with us. We also, with some frequency, put together an employment handbook that we share with clients. We have delayed a new edition of that so that the implementing regulations can be part of that. But we do intend to have an employment handbook that has general guidelines and principles. And we'd be happy to share that with attendees today if you get in touch with us and once it's available. We'll let people know on our website when we have that available. So I've got a great question from a colleague here about arbitrary dismissal. And the question basically is that companies often, when you terminate somebody, to avoid a dispute, will pay 3 months of compensation to avoid a lawsuit. And that's even if they're, basically the desire is not to go to court. How is this going to change that? And again, I think it's too soon to know. The unfair dismissal provision, it implies that potentially if there is a valid lawsuit that an employee files, that could give rise to a 3-month claim. The law is not clear. So the implementing regulations may give us some more detail. We also have to see how courts handle this moving forward. But I think that, we have generally guided clients on particularly executive level terminations, that the cost and time spent to litigate matters is frequently greater than the amount that you would pay out in some sort of acknowledgement that there could be an arbitrary dismissal claim. I think that there would likely continue to be that kind of practice. Courts here take a long time, it's very expensive to litigate, and there's a lot of uncertainty about outcomes. So to the extent that you can, in an economical way, manage the process and de-risk a termination, companies are likely to take that approach. End of service limit is not more than 2 years wage. Is that 2 years wage based on basic or basic and allowances? That's a good question. I believe it's basic. I would need to look into that in greater detail, but generally it's the basic wage, and that had been the way that it was previously. Again, this is only relevant if you have somebody who's been employed with you for a very, very long time, right? To have 2 years, you basically need over 25 longer years of service. And that's your wage of 2 years. So I guess that would be basic. And I don't have the law in front of me, but I will clarify that for you if you email me later. We have a working days calculation could mean an increase of around 30%. Is this something that ministry has confirmed? I've heard that it's confirmed that it will not be calculated on working calendar days, or else this is a significant impact on employers. We have not received any confirmation on that, and that could be spelled out in the implementing regulations. Again, there has always been debate about how end of service is calculated, and we've had this debate with clients for years. we would need to look at how current practice is in your company and then see how things are changing. But my reading is that the working days is that if you have a monthly salary of 10,000 dirhams basic wage, that the working days is you're not paid for rest days. You're paid to work, and that's what the law also envisions. So you would divide out that amount based on the working days in a month, 22 days. Agreed that that would be an increase if you're going with calendar days. But let's see. We don't have clear guidance on this yet, and there's a lot of uncertainty. End of service calculation change based on termination or resignation. Not any longer. So the previous regulations that said if you resigned prior to 5 years of service, that you had a third or a 2/3 deduction in the amount of end of service, that's gone. If you resign or not, you still receive end of service once you've completed a year. Will there be an updated end of service calculator provided online? Possibly, and that's something that we would work with our clients to as soon as there's clarity on this, to provide clear guidance on what our opinion is on how the law is interpreted and should be applied. I think, again, there's a lot of anxiety about this. I would just, if we can all take a deep breath and remember this, it is unlikely that you're going to have to deal with this for the next year, because people who are coming on board are going to have at least a year before they accrue end of service under the new law. The old law the new law permits you to continue to accrue end of service for folks through the grace period. And so all of the people who are currently employed who may leave in the next year would be paid out end of service on the basis of the old law through 2023, and we're likely to get a lot more clarity in the next year. And again, these new provisions are going to apply as of February 2nd, people coming on to the new fixed term contract model. And we are hopeful that the implementing regulations are going to give a lot more detail on that. Good question here about working models. Are companies forced to provide these options if employees request it? I.e., if a company only offers full-time, but an employee requests part-time, the companies have to make that option available. And again, we don't know what the implementing regulations are going to say, but generally no. I think that the idea is that if you are offering full-time employment, that's what's on offer. The parties may negotiate and contract for some other kind of arrangement, but just as you cannot force an employee to undertake particular kinds of work or formats of work, they cannot force you to take a full-time role and make it part-time. So you would, if you have full-time roles only, you'd be able to continue offering that, and it would be a requirement of employment to accept that role. I would say to you, and we haven't gotten into this in that much detail because it's been a very technical conversation today, but in 2022, post-COVID, to attract a world-class workforce, there likely has to be some flexibility. It's a case-by-case issue. It's about talent retention and acquisition, and so the law is the baseline of where you want to be, and all of those business considerations are things that our talented and sensitive colleagues in the HR space are working through with managers now to figure out how to get and keep the best talent out there. Wages paid in different currencies. Is this a mandatory provision if requested by the employees? I don't think so. I think that the law just opens up the ability to pay in other currencies. Previously, it stipulated dirham. So again, you'd have to have a contractual agreement or an agreement in writing at the very least. If it was outside of the contract, that some portion would be paid in another currency. I think a lot of, if you're doing your business in dirhams and you're paying in dirhams, then probably buying another currency on a monthly basis is a pain. But this again is another benefit that companies, I would tend to, as an HR professional, if I was an HR professional faced with this question, think of this as a potential benefit, a carrot that I could apply to employees. It's something that could make their life easier. And so if your company is engaged in transactions across multiple currencies or can easily purchase non-dirham denominated currencies, dollars are fixed, we all know that, so that might be the easiest thing. It could be a nice incentive and benefit to provide to retain employees. So we've got a great question from an attendee. Is the law prospective or retrospective? What about ongoing HR litigation? Will they automatically come under the new law, or will the court adjudicate them under the old law? I'm going to answer this, and then I'm going to hand over to Taskeen to answer more of these questions. Look, this is a law that comes into place in the second. So everything that occurs before that occurs under the purview of Federal Law number 8 of 1980. If there was a termination that occurred prior to February 2nd, then again, the provisions of Federal Law number 8 of 1980 would apply. So we're really only talking about this law being applicable, assuming that there's no delay in implementation, which does also happen from time to time here in the UAE. There's a delay. That's so the official gazette, there's something that's issued that says we're actually implementing this 6 months from now or whatever. But unless that occurs, this is going to apply to new stuff starting in February, old stuff under the old law. So you're going to have to keep that knowledge in your head for another year or so, if not longer. Taskeen, do you want to move forward with the next question? You're on mute still.
Apologies.
One of the negatives of Zoom, if we were in person, you wouldn't be on mute, but unfortunately that's the way we are. So please go ahead.
Sure. So looking at one of the following questions, does commission on sales require a defined term in the contract? I think that would be something useful. I mean, to clarify exactly how an employee will be earning. So yes, I think so. Will the labor law be implemented exactly as presented in the free zone? So as discussed previously by Jonathan, some of the free zones already do have their own labor law. So it would be applied in addition to those where the free zone labor law does not cover. And it does state in the UAE labor law that the new labor law, that the law is applicable across the state. Where can we find a copy of the new law? So this is available online on the MOHRE portal, along with certain updated guidances. However, if you have any trouble to find it, you can always reach out to us. Looking at next questions.
I'll answer this one. In case of company closure, what compensation should the employees receive? And I think it's simply notice period compensation. You would be able to terminate on the basis of termination provisions in the new law. And that would be it. You would still also be liable to pay unused annual leave, end of service, et cetera. And, I'll mention in the penalties clause, there are now penalties, explicit penalties that arise for people who don't pay benefits under the law. The query whether that fine goes to the company, or whether there are individual managers and shareholders who are held liable. But this idea of old idea of employers being able to run away and owe employees, especially blue collar employees, hundreds of thousands, if not millions of dirhams. The law now includes explicit provisions to penalize those companies and those people. So I think that's an attempt to address some of the more fly-by-night practices that used to occur here, and often were really negative for blue collar workers.
So I can take the next one as well. Can end of service be paid in over a period of time in monthly installments? So the new law actually stipulates that end of service benefits need to be paid within 14 days of the employee leaving employment. So 14 days is a really short period of time, as we know. So practicality right now, we're not sure how it will work. But right now the law says that all payments, all dues to employees need to be paid within 14 days. John, I don't know if you want to comment on the practicality of that aspect.
No, I think that's right. I mean, the question, there has been for many years a question of accrual of end of service. This should sit on your balance sheet as a liability. Companies rarely do that. And again, the same issue arises that when companies go bankrupt, often there's no money to pay employees. I think as long as you have an agreement in place and it is clear that you're either paying end of service into a bank account that is for these employees, or you're paying them on a monthly or annual basis, and there's a contract that's signed acknowledging the receipt of those amounts. This is a good and practical way to cover off those liabilities. The law doesn't have explicit provisions on this, but it's a difficult area. In the old law, and again, the new law doesn't quite state this, the end of service is based on the last salary, right? So you could start out at 10,000 dirhams and end up at 30, and ostensibly your end of service is then calculated on 30, not 10. And so that does give rise, as it increases, you should probably, if you're paying it on a monthly or annual basis, offset or increase the amount. But again, not clear, gray area. If you're going to do something like this, make sure that you paper it properly with the client and have clear evidence that you've made these payments. Do we need to revise all current contracts of employment if there's a non-compete clause? Well, you're going to have to revise your contracts within the next year anyways. I would use that as a time to look at non-compete and confidentiality provisions. If you haven't already, and we've done seminars on this in the past, you know, that's probably a place where you want to get a lawyer involved to tailor a really, really nice non-compete provision that protects the company and isn't overly burdensome on employees that don't need to be burdened. And we have a question here. We have to update the contracts. Yeah. So anybody with old contracts is going to need to update those within the next year. If an employee resigns before the effectiveness of the new labor law, but the end of service period falls after the new labor law, what's the applicable end of service? We talked about this. If you're currently serving and you resign, you're going to accrue and pay out under the old end of service provisions for the next year. So you don't need to worry about the new end of service calculation. Hopefully we'll get a lot more clarity over the next year. But for the next year, anybody who leaves or is terminated is covered under the old provisions. Got a great question here on maternity, and why don't you, I know that you covered that, Taskeen, so I'll hand off to you.
Sure. So our next question, under maternity leave, nursing break reduction from 18 months to 6 months. If the employee has given birth in August 2021 and is currently entitled to the nursing break, do we follow the old law of 18 months or the new law of 6 months, which will apply? In this case, I'm inclined to say that you will follow the old law of 18 months. As we saw earlier, contracts should not be updated to apply with the new law unless it's for the benefit of the employee right now regarding limited contracts. So since the birth happened under the old law, I would say 18 months rather than 6 months.
We have a question about termination while on leave. There was an old provision that you couldn't terminate during leave. And there's a new provision that makes this explicit. Basically, you can't do that. And so a termination would only be applicable once the leave ends. So, you know, you would need to wait, or even if you did serve notice, it wouldn't be applicable until the leave is up. Yeah, we have a couple of questions about overstay fines. Who's responsible? You know, the law doesn't cover that. So let's say it's somebody overstays, you've paid their end of service, there's a lawsuit. Who's responsible for the fines? Again, there's not clarity on that in the new law. Maybe the implementing regulations will cover that off, but that has been something in the past. It's been really problematic. Generally, those overstay fines are the responsibility of the employee, but we'll have to see. We don't have guidance on that. I'm just going through questions here, sorry. We went from 20 questions to 70, everyone. So clearly you have lots and lots of unknowns. I'll say we've got about 5 minutes left. And so why don't we try to take a couple more, and then, you know, depending on interest, we can either field these via email or potentially we'll have to consider some other option. But I know that you know, if we answered all 70, we'd probably be here for another hour. So I don't know if people have the time for that today. Taskeen, do you see any questions that you're on the field? We're going through these. So question, employment contract templates will be provided by the ministry. Yeah, that's what we've been told, and they should be coming shortly. I think they'll look similar. They'll be very standard form templates like we have with the ministerial contracts now, and they'll likely still require supplemental agreements that you'd want to have your lawyers or HR professionals work on. End of service calculation after 5 years, is it 30 days or working days? It's 30 days, 30 working days. Again, we've discussed this a little bit. My reading so far is that if you have a monthly salary, it's going to be you're going to be liable for a month of compensation. So 10,000 every year would be, if it's 10,000 dirham basic salary, you'd have a 10,000 dirham liability.
I have an interesting one for you, John.
Go ahead.
What do we do in a situation where an employee agrees to renew the contract and then resigns after visa renewal? Can we charge the employee with the visa expense?
From what we read in the law, no, generally no. And I think, again, where these chargebacks are considered and are relevant is in probation period. And the idea here is that we don't want to penalize employers for bringing in new workers and then allowing them to be part of the labor market and leave to another employer without there being any, in an unfair way for the person who brought the employer who brought that employee. So I think here, if they've served a 3-year period, there's a renewal and they move somewhere else, I don't think that would be applicable. You would not be able to charge expenses. And again, I think, it's difficult as it is to say this to employers. You need to, in terms of your budgeting and ROI, this is a fixed cost expense of companies that need, especially in an expat market like this, that need to be borne by the company. That is the fair and equitable approach. If somebody's worked for you for 3 years, you've likely earned a sufficient return off of them. It's unfortunate that they would leave after a renewal, but I don't see a basis for clawing back on that. What's the deadline again to amend contracts? This would be next year, February 2nd of next year. And one of the things, the question is, how do we do this? And I'm just going to throw out there that you're going to have a number of, likely at least 50% of your employees are going to have visas that expire in the next year, right? So for your current employees, you're unless you've just renewed them, I just renewed in December, you're going to need to have, this is going to be an easy opportunity to take people off of an unlimited term and to move them to a fixed term. For people like me who have a brand new visa, we're going to have to, consider economically and otherwise what the best step is, whether we wait a year or how that works. But that's a business decision that the HR team will need to make with their managers. And it also impacts, of course, likely, and again, this is where immigration and labor law get together, dependents, school year, all of those wonderful things that we have to deal with when there are families in tow. So this is going to be a logistical headache for unfortunately, for a lot of HR folks out there. So we have a question about employers are prohibited from confiscating employees' official documents. Workers shouldn't be forced to leave the country following the end of the term. What happens to the passport custody after cancellation? So it has been we understand that practice in the UAE is to retain, especially blue collar workers' passports. This is a practice that is illegal. The ministry has been very clear on this. The police are sometimes involved if there is a passport that's being held by employers. Don't do this. It prohibits the freedom of movement of employees. Again, there are more sophisticated and equitable ways to manage employee retention than to hold a passport. So your employee should retain their passport and their travel documents, even if that increases the risk that they leave. That's a risk that you're going to need to bear from a legal and ethical standpoint. In the private sector, can we avail the grace period of 1 year and only start February? So that's for the conforming is for existing employment relationships. So yes, if you have a new employee that comes on February 5th, it's going to be the new, unless the implementing regulations don't come into place and we're in a weird position, you're going to need to go with the new labor law starting in February. Great question. Will the new ministerial implementing guideline, the regulations, be immigration binding as well? I.e., if there's a 3-year contract, will there be a 3-year residency visa? Yeah, that's a great question. We don't know. The GDRFA hasn't issued, as far as we're aware, guidance on this. The ministry, MOHRE, has not issued guidance, but one would assume it would make sense that if you're issuing remember, it doesn't have to be a 3-year term. You could issue a 1-year renewable contract. But ostensibly, if you're going to be issuing 3-year fixed term agreements, you would want to try to have a visa that would be applicable for the same period. Some free zones issue 3-year visas, but onshore, it's a 2-year visa, and that usually is linked to an unlimited term contract with a 30 to 90 day term period. So again, uncertain, but a space to watch. And again, that's where the logistical headache, I think, is going to come in for a lot of people. I'm going to answer a final question here, and then we're going to let people get in touch with us via email or otherwise. How do we pay in other currency through WPS? Good question. I don't have a great answer for that, and I don't know how in practice it's going to be implemented, because you're correct that WPS is basically a dirham-based system. I would say that there are, bank accounts here can be euro and dollar denominated, and other currencies as well. So theoretically, there'd be nothing stopping you from making dollar-denominated payments through WPS to a Mashreq USD account. But again, that's a logistical issue, an administrative issue that's going to have to be worked out if that's a benefit that you decide to apply to give to employees. We have a final, not a question, just thank you for putting this all together to clarify good points. I'm going to use that as a springboard to thank all of you for attending and listening to us go through this. We have always thought of ourselves as, yes, we're lawyers, and we are an enterprise that exists to serve clients, but we're also a resource for the broader community, and we hope that we can continue to have this conversation with our friends and colleagues in the legal and HR space to educate each other and to get up to speed. So please, we will be as active as we possibly can while maintaining our legal practices and personal lives to alert people to what is going on. We welcome inquiries and from existing clients and potentially new ones. And I hope that in a month or two, when there's more clarity, we can come back and have an in-person event, meet people, and have a robust exchange of a discussion on what's happened. There's so much uncertainty, and the way this is going to get resolved is hardworking people searching for answers and figuring it out. And there's a lot of anxiety, but trust me, in the next year, we'll look at this period as a useful time where I think we transition to a new system with a lot of benefits. So let's be optimistic moving forward with this law and with 2022, and we would love to be a resource for you and to be part of the conversation as you progress. Thank you very much. Taskeen, any closing thoughts?
Just thank you so much all for attending. I hope that it's been informative, and we look forward to continuing this conversation on. Have a great day all.